Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. Oh my God, our favorite grandma victim was back in court today. Well, via Zoom, but you know what I mean. Donna Adelson had another pretrial conference to suppress or not to suppress or just give it a rest. Her side could not decide. So they want to get Wendy's book out, Wendy's divorce out. Hell, they might even want to get Wendy's first period out. But let me get this intro in and then we'll talk about it on the other side. All right, we are back with another video. So yeah, I watched this earlier on Trial TV Live. Some of you guys may have been in there. We all had thoughts, and I'm gonna use this view though because we get to see Miss Adelson, and I'm gonna react as we go along. I have some notes, like some of it I just feel is a little bit pedantic. Also, I'm worried about the defense and their timing. So remember last time that we met, I think it was a month ago or maybe earlier this month in March, they were asking about possibly having more time, and the judge was like, we're still over, 2 months out, so let's see how far we can get, which I interpreted as Mr. Or Judge Everett did not want to go back to Mrs. Everett and reschedule that June 3rd start date. But I don't know. I'm getting the sense they need more time, but we'll talk about it. Let's just hop right on in. Get Miss Adelson on the record.
Mrs. Adelson, can you hear me?
Yes, I can.
Right, we can hear you clearly in the courtroom as well. Your counsel or counsels are with me in the courtroom as well as the state. Mr. Zellman or Ms. Fulford, whoever would like to go first, or Ms. Dugan.
Your Honor, first thing I want to address, I think it was last week, the week before, Your Honor issued the order concerning the prior investigator. When we were first before the court in December, we were told that the defense would have the benefit of what already occurred. I certainly understand the conflict issues, but our client is being punished and prejudiced in her ability to defend herself, not based on her actions, but on the actions of her former attorneys. It's our understanding that one of the things that the investigator did was travel down to South Florida, take pictures.
So as the backstory here, the judge has precluded them from using Donna's previous investigator due to the conflict that was caused by Rash Bomb. So I don't know why he's giving this sad song to the judge. Like, it is what it is. They cannot risk having the trial overturned, right? Or having the verdict, however you want to say it, overturned. So he's right now spitting in the wind, in my opinion, but I guess he just wants to get it on record that his client is prejudiced. She chose Rash Bomb, though, so I don't think she's prejudiced. It was her choice. She willingly chose him. She was asked on the record multiple times and agreed to waive a conflict, but she knew, it was always there, so.
Identified times of travel. We don't have those materials, and we're asking for an exception to the court's order to get those materials, not his reports that he generated from interviewing individuals.
The raw materials.
Just the photographs and those specific notes. And if we want to do it in process where Your Honor makes sure that that's all that's being transmitted to us, fine. But otherwise, our client's going to have to go to the expense of hiring somebody to do that same exact task.
Problem with this, Mr. Zellman, is if in any way conflict bleeds over, that compromises the trial itself. The whole point of stopping the trial because of the conflict was not to have to do this a second time. Your client did select who she wanted to represent her. There is a conflict issue tied up in that. At this point, untangling all that is ensnared by the conflict presents more issues. Does the state wish to be heard?
Would defer to your ruling since you did the in-camera review, Judge.
As to whether any raw materials that were obtained by the investigator could be used, I will give this additional consideration. However, any report that he has made that remains subject to the ruling, him assisting with the defense remains subject to the ruling. Other matters that you need to address, go ahead.
So he's not going to rule from the bench on this one. On most of them, he's actually not going to rule from the bench. I don't know if I gave credit or not. This clip is from Law and Crime. I remember saying I was watching it with you guys on Child TV Live, but this clip is from Law and Crime. He is not going to rule from the bench on this. This is my thing. If you take someone else's pictures, like say for example, she's going to get a new investigator. I think she's trying to save some pennies, so she doesn't have to pay again for someone to go take the photos. But what does the new investigator get from looking at someone else's photos? Maybe you glean something, but wouldn't you want your investigator to go down there and take their own photos? I mean, also get those, but I don't know that I would risk putting the whole trial in jeopardy. We see how upset she was last time when it was canceled the day of with all the shenanigans. I would just pay the cost. Stop being cheap, Donna. That's how you got here in the first place, because you didn't buy a round trip to Vietnam.
Yes, Your Honor. In December, you entered the order setting court proceeding dates and procedures.
Yes,
I've conferred with the state and we have a few requests for changes in those.
go ahead.
With respect to the discovery deadline, which is now set for Wednesday, April 30th of 2025, we would like the order to be amended, if Your Honor agrees, to say that deadline will remain. The exception would be if the parties agree to depositions outside of that date. We've had some problems with getting some depositions scheduled when everyone is available. We already have one set in May 14th, so we would like just the opportunity to hold depositions past April 30th if everyone is in agreement.
Ms. Dugan.
No objection.
Very well, the deadline will remain in place. As to whether this would affect any motions that would need to be heard, that would occur once the issue presents itself, but you may schedule the deposition if you need to.
Thank you, Judge. We also were requesting that because of the discovery issues, that we extend the pretrial motion filing deadline to May the 9th and to presenting the final witness and exhibit list to May the 13th. And the state had no objection to that either.
Ms. Dugan,
No objection.
those dates then will be moved as requested by the parties.
Thank you, Judge.
Any other matters the defense needs to raise?
Your Honor, we had previously submitted a proposed order concerning the wealth evidence, and we had
Yes.
addressed it by email with your judicial assistant in the state. And Your Honor indicated that we would address it here this morning. The purpose of submitting that is so that there is complete clarity on the court's ruling, that there's not an issue. We are not trying to get into a situation where we're having to seek a mistrial.
As to that, I reviewed the original order and also what was proposed. They didn't exactly coincide. Is there something in particular that you believe needs to be clarified based from the original order?
I don't think that there is. I think that there's a difference in opinion as to what the court's order meant.
I reviewed the transcript on that as well, and I believe as it went to the state presenting any evidence of motive, or specifically that Mrs. Adelson was somehow involved with the offer of money relating to the, I believe, relocation of the children, that evidence would be permitted as far as any general evidence concerning her money, such as what her net worth was on a particular date. That was not going to be presented. But again, as it relates to presenting evidence on motive, that would be presented. What is unclear about this?
I think that clears up the potential confusion, Your Honor.
All right, Ms. Dugan, do you need to be heard on this point?
I love Judge Everett. I would be afraid to be his child, though. He was like, wait, I didn't see him, but this is how I imagine. What is unclear about this? You know, if you're like a teenager and you're like, oh, I didn't know what you meant. What is unclear about this? Nothing, sir. I will get to it straight away, sir. Thank you.
We've already filed 2 additional motions in limine. There are at least 7 more that we are still working on, and we are hoping to get filed in the next few weeks. When we were here last, I had indicated
Whoops, sorry, guys.
that there was another motion to suppress. I'd hoped to file previously, but given the depositions that are scheduled, I want to wait until after those, in the middle of April, to get that filed, just to solidify some of the testimony. So that will be filed before the end of April.
Right. As to the motion in limine concerning the use of the book for impeachment, are the parties capable of handling this matter today?
I'm not prepared for that.
We can, I believe that the state stance is that much of that has already been heard before as well, but we could get with your assistant and set a time for that to be heard.
Go ahead, so that way that matter can be resolved somewhat quickly, I believe, compared to the other motions.
So Ms. Dugan for the state is saying that previously this was admitted, and so what they're asking for is to not allow Wendy's book in Something in Our Lives, whatever it is, with her eye. Her dad redid her eye to make it look bluer than it is, or more blue. And they don't want it in. Defense doesn't want it in, but they have used it previously to impeach Wendy's testimony, because we know if her mouth is moving, she's lying. So she didn't want to admit that on the stand, that she didn't like Tallahassee. That's really like the root of it. There's some other things in there. I wish Danny would have read that book. I haven't read it, but it just seems like there was some foreshadowing in there. But anyway, so that's what this one is about. And for some reason, defense is not prepared to argue, so they're going to have to schedule another hearing. Keep in mind, this was supposed to be the last pre-trial conference, but now it's not going to be. I think I have that right. I didn't see another. Oh, maybe there's a 4/25 date. I take that back.
But there should be, look at the calendar.
Now I've covered up Donna's face. She looks a little more put together today, no?
Probably handle either a 30-minute or 45-minute motion on that. Even this week, if all parties are capable of handling it.
This week. Can we do it this week?
State defense.
Defense is not ready.
Calendar, Your Honor. It looks like I'd be available. I could make myself available almost anytime Thursday and anytime Friday.
Ms. Dugan,
That should work. Maybe Thursday afternoon, we could set something. If I could get with Ms. Kappelman, and we'll email Lynn this afternoon, would that be okay?
contact Lynn to see what time on Thursday we can go ahead and address the issue
Sir.
Yes, sir.
of the book.
Yes, sir. And then lastly, on the venue issue, we have the materials from our expert. I was hoping to file it last night, but still.
This is regarding their expert testimony. They're trying to get a change of venue. I believe that Judge Everett said we've got to take a swipe at seating the jury in Tallahassee, but they're allowed to bring in this presentation. So he's giving a status on that, because they feel like she can't get a fair trial in Tallahassee because of all the exposure.
Finishing putting all of the materials together. We also have spoken with the state about their position on filing those materials under seal. That motion to file under seal and the proposed order is already done. I could submit those today when I get back to the office. And then the materials themselves, I'd like to say tonight, but realistically, probably tomorrow.
Please file them as soon as you're capable. If there is no dispute from the state concerning whether it's under seal, you may do so.
Ms. Kappelman indicated yesterday that there was no objection from the state, so that portion's already resolved.
Very well. Do the parties need another case management before we get to the more substantive dates and the orders?
State does not.
Your Honor, at this point, I don't think that we do. If something arises that we cannot work out amongst ourselves and we need to get court intervention, we will certainly contact your judicial assistant.
Well, let me briefly look at the order that was previously set. We're setting all of the dates and deadlines.
Do you guys think Donna wanted to come to this? Why? She's not. Well, I guess she's being nosy. She's checking in on what her coins are doing for her. I noticed a little bit of a smirk when she was.
Pre-trial is already preset by order for 5/16 at 9 o'clock. That will be the next date in which the matter will be addressed outside of any other motions. Unless either party has anything further to address, we'll be in recess for this case.
Sir.
No,
Thank
sir.
you, Your Honor.
That is the conclusion of the hearing. Have a good afternoon, everyone.
Good afternoon, Judge Everett.
Yes, sir.
Woohoo. So yeah, that was it. They're trying to get things suppressed. The wealth, the book. There's one more thing. There's also one pending about the divorce, and I don't think we covered that yet. About like Donna wasn't a party to the divorce. Hopefully I'm not mixing that up and it hasn't been sorted yet. But yeah, so that is what's going on with Miss Donna Adelson. We're progressing ahead. Hopefully you saw the live I did with Judy last week where we did a reading of Wendy's deposition in the second trial of Katie McBanawat because Donna's attorneys flew out to Austin that morning to depot Wendy. And then as I understand it, Sigfredo has been depoted. I'm trying to get the other police reports where Isom talked to people who were bunked with Sigfredo. I have the one, but I did see like Jay has them, and I just like to get my little hands on them and see if there's any other. I don't know if they're called informants, but any other like Joe has snitches. So that will be interesting. I think that's it. Oh no, I've got body camera footage for you guys. Donna's long ride to Tallahassee. Or long ride from Miami, however you want to say it. Keep an eye out for that. That is coming. And then on Wednesday, I don't know when you guys will be seeing this, but on Wednesday, the 26th, Sarah Boone is in court. So we'll be taking a look at that in family court. Also, I have her latest updates from prison from February and March from where we dropped off last time. She finally did something bad. I've been waiting on these behavior reports. We got one. As soon as I finished doing all the calls, the call log, redacting the numbers, researching whose number it is, there's quite a few new people on there. I'll have that up. So look for it maybe Wednesday, maybe Thursday. But just, turn your notifications on because your girl just likes to drop them videos when they're ready, when they're hot. We can't wait for a schedule. What? The information is hot. We got to get it to you. All right. I appreciate you. Let me know your thoughts on Little Miss Donna's situation. The detective, do you think they should, you or the investigator, repurpose those photos, or she should just hire someone and get some new photos? The new investigator goes down there and gets all the things. I feel like Donna is the one pushing for this because her attorney should know better. She seems to be driving the truck. She's going to drive it right off a cliff, girl, because there's a warm place in hell waiting for you. And while it's waiting for you, you're going to sit in prison and then go to hell. All right. Talk to you guys later. Toodles.